Hello everyone, this is Crypto BitLaw back with another blockchain legal brief, and today we're going to be covering the SEC versus Terraform Labs case, and in particular an update to this case wherein the court ordered Do Kwon and Terraform Labs to comply with an SEC subpoena. And so before we dive in, if you enjoy this content, please hit that like button and subscribe to our channel, and if you'd like, you can also follow us on Twitter. Our handle is @CryptoBitLaw. So with that said, let's read the news. So as we can see here, Decrypt reports that U.S. court orders Terra and Do Kwon to comply with SEC subpoenas. They say a New York court has ordered Terra and Do Kwon to comply with subpoenas issued by the SEC, which were issued at a crypto conference last year. And before we go on, if you'd like a little more detail into what this case is about and pretty much the framework regarding these issues, you could check in the description down below. We linked to another longer form video where we do a more in-depth analysis and overview over this particular case. But with that said, continuing on, the article states that the United States District Court in New York has ordered Terraform Labs and its CEO, Do Kwon, to comply with subpoenas issued by the Securities and Exchange Commission, or the SEC. The subpoenas were issued in relation to the SEC's investigation of a decentralized finance project built on Terra called Mirror Protocol. And for those of you that don't know, what Mirror did, or what it does, is it mirrors the prices of underlying assets. So it gives you a tokenized version of like a derivative project, like let's say Tesla stock or Google stock. You could trade them as tokenized versions on this Mirror Protocol, right? And so naturally the SEC, they're having none of it. They're like, hey, this is a security. And so they're trying to eke out more information in the form of these subpoenas and actually assert their jurisdiction over Terra and Do Kwon. Continuing on, it states, according to the court filing, the court reviewed all relevant parties' filings and held an oral argument on February 17th, 2022. And just of note, technically, this isn't really at the stage of oral argument. Oral argument, that term of art really refers to advocacy that's done on behalf of an appellee or an appellant during the appeal stage. After you file a brief or an appeal brief with an appellate court, you can present oral argument to that court or that panel in an effort to bolster your position that was stated in your brief before the court. That's an oral argument. At this stage in the litigation, pre-trial stage, you're going to advocate before the court in a hearing. So that's just a minor distinction, just for all the legal nerds out there. It continues on and states, quote, for the reasons stated on the record at the February 17th, 2022 conference, the SEC's application is granted, and Terraform and Do Kwon are hereby ordered to comply with the above referenced subpoenas, wrote the United States District Judge Paul Oetken. Last October, the SEC served Kwon with subpoenas at the Missouri Mainnet Crypto Conference in New York. The SEC's focus is on Mirror Protocol, a platform for creating synthetic crypto versions of popular stocks like Tesla, Microsoft, and Airbnb. In other words, users can buy and sell synthetic versions of stocks that would typically be sold elsewhere, like Tesla stock on the New York Stock Exchange, at nearly identical prices on a blockchain. So those were those tokenized derivative assets we were talking about earlier. Terra's Kwon, who previously denied receiving the subpoenas to the Defiant, then reacted by suing the SEC, claiming that the subpoenas were, quote, improperly issued and served. The lawsuit added that the SEC failed to keep its investigation confidential. Quote, the subpoenas were served on Mr. Kwon in public. Mr. Kwon was approached by the process server as he exited an escalator at the Mainnet Summit while on his way to make a scheduled presentation that was not about the Mirror Protocol, the document also said. Shortly after Kwon sued the SEC over receiving the subpoena in public, the Terra CVO opined about the crypto regulatory landscape. Speaking at the Yahoo Finance All Markets Summit in October, Kwon said friction between regulators and the crypto industry often leads to frameworks that are a little bit more accepting of innovation and change. He added that the tension between regulators and the DeFi space is a trend occurring around the world, with the United States being no. All right, so this was an interesting development in this case. A few thoughts on this. I think first and foremost, I know that Do Kwon has been vocally critical in the past in public interviews and whatnot regarding his disdain for regulatory agencies like the SEC and his belief that they stifle innovation. And, we could see here in this article that was linked, Do Kwon, he said that, that DeFi may not fit in nicely with current regulations and there's friction between him and the SEC. And in a sense, it kind of feels like he was almost flaunting the fact that he was a, South Korean national and not really subject to the U.S. jurisdiction. But au contraire, that's not really the case. Despite the fact that he's South Korean and he can try to, avoid jurisdiction in the long arm of the United States jurisdiction in a foreign country, that doesn't really reconcile too well with the extradition treaties that we have, in particular with the Republic of Korea. Here's a copy of the treaty. And further, it has happened where there have been extraditions from Korean nationals to the United States, either, on the basis of here we see antitrust law, but it's the same, two sides of the same coin. If Kwon is roped into the United States legal system on the basis of securities law violations, they're going to go get him. They're going to bring him here. He's going to be subject to this. The United States, the United States has such a broad influence over the developed world and the westernized world that you can't run and hide from this. They're going to find you, especially if your country has one of these extradition treaties. So I think that this is one important thing to consider. We're going to link both of these in the description below. Also, it's interesting to see, as they noted here, Kwon was served with the subpoena by the SEC as he was about to hop on stage at this conference in the United States, right, the Masari conference, and the private process server just, look, here, take this, surprise, you're served. And his response was to try to play hardball by actually turning around and suing the SEC, right? And I feel like that's it, kind of like he poked the bear in a sense. And the only thing that you're going to do by doing that is just piss them off. These regulators, they have a bone to pick with you. And so he tried to sue the SEC. I guess we'll move on to these dockets right here. We have these two cases, the SEC versus Terraform. This is one, and then the other one, Terraform versus the SEC. And as we can see here, Terraform tried to sue the SEC, and the most recent development was January 18th. The SEC moved to get Terraform's case against the SEC dismissed for lack of jurisdiction. And it appears that we don't have any orders regarding that. What I believe would happen, what would likely happen if it has not already happened based on the information we have in front of us, is that these two cases would get consolidated into one case. More likely than not, this particular case right here, SEC versus Terraform. Okay, so I unearthed a little more information here. We see a different docket monitoring service, Pacer Monitor. We could see the entries on February 14th. There was, as they refer to it, oral argument on the pending application to enforce administrative subpoena held by telephone conference. And so I think that was just a telephonic hearing in a sense, right? And so that was held. And then here was that most recent entry on February 17th. It was an order for the U.S. Securities and Exchange Commission. They filed an application for an order requiring compliance with the investigative subpoenas for documents and testimony served on Terraform Labs and its co-founder and chief executive officer, Do Kwon, in September of 2021 in connection with their investigation of the Mirror Protocol. The court has reviewed all parties' filings and held oral argument on February 17th, 2022 by telephonic conference. For these reasons stated on the record, at the February 17th conference, the SEC's application is granted and Terraform and Kwon are hereby ordered to comply with the above referenced subpoena. The order stayed for 17 days, or actually rather for 14 days, to permit further briefing regarding a potential stay pending any appeal of this order. So that's what happened. This played out before the district court. SEC served and filed the subpoena on Do Kwon and Terra, right? Terra fought back against it. They're like, hey, we don't want to do this. Court, don't make us have to comply. SEC came back and they filed an application for an order requiring compliance. They battled that out with motion or memorandum in support, memorandum against. The court held argument on it, which was, I guess, a hearing, I guess their version of a hearing, right? And then after all of that, the court said, hey, we're going to grant the SEC's order. Do Kwon and Terraform, you have to comply with the subpoena, but it's not over yet because they still have 14 days, Do Kwon and Terraform, with which to appeal or seek review of the district court's order. So Terraform and Do Kwon can actually file for a writ of review, right? And have an appellate court review the district court's order. So it's not totally over yet, but this was a battle victory for the SEC. Haven't quite won the war yet, but they're starting to gain. The balance of power is favoring the SEC, and they're starting to get leverage. So that's where we stand in this. Really, really interesting stuff. We're going to keep continuing to follow this case and give you updates as it develops. I guess on that note, if you guys liked this content, please hit the like button and subscribe to our channel. We really appreciate that. That will help us grow and get the message out there and keep doing what we're doing. Also, you can follow us on Twitter if you'd like. Our handle is @CryptoBitLaw. And I guess on that note, thanks for watching this video. We really appreciate it, and we'll see you guys in the next video.